The anger was palpable. He was yelling at my client during pretrial testimony. He was sarcastic. He was antagonistic. I put my hand up to stop him. Find out what happened. Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. So now my client is being questioned by the defense attorney. He was one of the most obnoxious defense attorneys I've ever encountered in my career. And I've been doing this more than 25 years. So now, he was nasty, he was arrogant, he was sarcastic. And by the way, I knew he was doing this to push my client's buttons. And ultimately, he made my client cry. I put my hand up, I said, "Stop right there. We're done." And now, he started arguing with me. And now he started calling my client names. I said, "Here's what we're going to do. This deposition is finished. This is over." I told my client to leave and I would talk to her later. I then sat in the room with the court reporter and I put on the record exactly what this attorney had just done. That this defense attorney has harassed my client. He's been yelling at her continuously for the last half hour. He's screaming at her. He's antagonistic. He does not stop, even though I object to these questions and I object to his attitude and the way he's asking these questions. So why did I have to make a record of that? I did it to protect myself, my client, and our case. Why? Because now the defense attorney could go to the judge who's supervising the case and say, "Judge, they did not complete the question and answer session. They deprived me of the opportunity to learn all this information that I needed to. I still had hours of questions to ask this witness, and they simply got up and left." Well, now, here's a complete record of exactly why we had to do what we did. And it's important because, remember, when the attorney goes to the judge and explains what occurred, unless there is a clear record showing exactly what the attorney was doing, the judge is never going to know. And the judge doesn't know, and he won't be able to tell just from reading a dry transcript what the emotions were during the course of that questioning. He won't know that somebody was screaming. He won't know that somebody was yelling. So that's why it's important in protecting my client's interests. I have to put down on the record the fact that the attorney was obnoxious, was screaming, was yelling, in order for the judge to ultimately see that what we are saying is in fact occurred. And now the defense attorney, when he tries to ask for another deposition to have my client come back, now the judge is going to look at it and see whether or not this information really occurred. And if it did, there's a very good chance the judge is going to say no to the defense attorney to have my client come back, and that he waived his right to question my client. So why do I share this quick information with you? I share it with you to show you one extreme of what can occur during the question and answer session, during the pretrial testimony in a case here in New York involving medical malpractice, involving an accident matter, or even a wrongful death matter. Now, I will tell you this does not happen very often. In fact, it is the exception rather than the rule. You know, I realize you're watching this because you likely have questions or concerns about your own particular matter. Well, if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.